volunteered with PAC in many different capacities and has even worked with PAC. And I know some of you have come into her. We did a workshop on My Jerusalem website, which Hiba was our lead researcher on that initiative. So Hiba, she was a newly admitted lawyer. She recently got sworn into becoming an attorney. She holds a master's degree in international law and human rights from our Washington College of Law American University. And I always say this, Hiba is probably one of the smartest people I know. So without further ado, I'd like to introduce Hiba to you all and give the mic over to Hiba.
Okay, thank you so much, Rania. Hello, everyone, and assalamu alaikum. My name is Hiba Birat. As Rania stated, I'm a newly admitted lawyer to the state of New York. I did my master's degree in international law and human rights in Washington College of Law American University. I did my bachelor's degree also in law in Birzeit University back in Palestine. I'm here with you today, inshallah, to talk a little bit about legal implications of BDS movement, some claims, counterclaims. What does American law say? What does the international law say? What is the movement currently facing in the international arena? Before I start, let me just share my screen with you. I'll walk you through the slides, inshallah, so you can, guys, easily follow the discussion. Second, and from the beginning, great. Okay, so on July 9th, 2005, which marked the first anniversary of the International Court of Justice decision on the legality of the construction of the wall in the occupied Palestinian territories, in which the court concluded that the construction of the wall was illegal in violation of international law and that Israel had an obligation not only to dismantle the wall, but also to repair any harm caused by the construction. Around 171 Palestinian civil society organizations came together and called for the establishment of BDS Movement, which stands for Boycott, Divestment and Sanctions Against Israel. Now, the movement was meant to use non-violent punitive measures against Israel until it meets its obligation under international law to recognize Palestinian people's right to self-determination and until it fully complies with international law. The movement that is inspired by South Africa anti-apartheid movement has three main demands, and I want you to focus with the demands because we're going to go back to demands when we speak about the international law position. The first demand of BDS is to end the occupation and colonization of land and dismantle the wall. The second is to recognize fundamental rights of Palestinians, Arab Palestinian citizens of Israel to full equality. And the third is to respect, protect, and promote rights of Palestinian refugees to return to their homes and properties as stipulated in United Nations Resolution 194. Now, as we all know, Israel is maintaining a regime of apartheid, colonialism, and occupation over Palestinians. This is only possible because of the international support of Israel. You know, governments fail to hold Israel to account. Institutions and corporations are either directly or indirectly helping Israel to maintain its apartheid regime through financial assistance. Now, what BDS is trying to do here is to pursue accountability for Israel outside these diplomatic channels. The same is going on with the ICC, the International Criminal Court, which also is a rising arena. Both of them, BDS and ICC, unfortunately, are facing hostile reaction by the United States and by Israel. Now, in addition to raising awareness about how Israel is violating international law and Palestinian human rights, BDS is trying to push institutions, governments, and organizations to meet their obligations under international law and shift their policies to end their support for Israeli human rights violations. So in addition to withdrawing support, BDS is trying to withdraw investments from entities that are deemed complicit in Israeli human rights violations of Palestinians. BDS is actually deriving its legitimacy under international law from two main frameworks. The first framework is the legitimacy of BDS demands that are firmly based on principles enshrined in international law. And the second framework is the BDS itself, the movement itself, as a manifestation of a combination of rights and freedoms that are deeply rooted in international law. Now, before I talk about the two frameworks in more details, let me give you a very quick and brief introduction about international law and position of Israel under international law. So international law is a body of rules that is established either by custom or by treaty, and that is recognized by nations as binding in their relation one with another. Of course, we have more progressive definitions of international law that would add up to international actors who are subject to international law rules. So in addition to a traditional national state, we would have some armed groups, some kinds of militias, some kinds of offshore companies, some kinds of intercontinental corporations, and even some kinds of political entities that did not exhaust all components of a traditional national state under international law. Now, international law mainly aim at preventing war, or at least regulating its conduct so as to mitigate any harm caused by its occurrence. Now, in 1945, when the Second World War was coming to an end, the United Nations was established as an effort for international cooperation. Currently, around 193 member states are represented in General Assembly. However, the only binding decisions made by the United Nations are those made by Security Council, which has 5 permanent members: France, Russia, China, United Kingdom, and United States, and 10 non-permanent members serving 2-year terms. Now, in addition to the Security Council and General Assembly, United Nations also host the International Court of Justice. Unfortunately, decisions made by the ICJ, or the International Court of Justice, are unenforceable due to lack of political will by international community members. Now, in 1949, and this is very important, the international community witnessed the passing of 4 Geneva Conventions, the 4th of which addressed the humanitarian protection of civilians in war zones. Since then, 3 additional protocols have been added to the 4 Geneva Conventions. United States and Israel are only parties to the 3rd. In 1993, though, the United Nations Security Council concluded that the 4 Geneva Conventions had passed into the body of customary international law, making them binding even on non-signatories in times of armed conflict. Now, since its establishment back in 1948, Israel has been ignoring international law, and its military occupation of the West Bank and East Jerusalem, its blockade of Gaza, its colonization of the land through expansive settlement activities, daily assaults on Palestinian lives and properties, addressing and targeting civilians, making them vulnerable to extrajudicial killings and collective punishment through home demolitions, torture, arbitrary arrest, unlawful prosecutions, and all these are violations of international law. For example, Palestinians in East Jerusalem do not hold the Israeli citizenship. They do not hold the Palestinian citizenship either. They are regularly disposed of their lands and residency permits. There is a 2018 amendment to the Israeli basic law that established that only Jewish people are have the rights to self-determination. Palestinians who are citizens of Israel also face a racial discrimination, systematic racial discrimination that is enshrined in more than 60 Israeli laws. Palestinian refugees around the world comprise one of the world's largest stateless population out there, whereas a Jew who's either a convert or born to a Jewish mother is automatically entitled to Israeli citizenship. Now, when we look at these violations and we review the 3 demands of BDS, we can see how BDS and demands of BDS go in line with international law. So for example, the first demand of BDS is to end the occupation, the colonization of the land, and to dismantle the wall. Now, under international law, West Bank, East Jerusalem, Gaza, and the Syrian Golan Heights are occupied. Military occupation and annexation of land by force are both prohibited under international law. And United Nations actually has called upon Israel to end its occupation for Palestine since 1967 in many resolutions. One of the most famous resolutions is 242. Whereas for the settlements, settlements, and since the initiation of Oslo peace process back in 1993, has been dealt with as a final status issue. To be included in the ultimate territorial negotiations. Now, Israeli citizens and Israeli civilians who used to live in West Bank then were incorporated in Area C. Area C includes more than 60% of the West Bank. With a 99.7% of Palestinian civilian lands there were granted to Israeli civilians. Now, the remaining 40% of the West Bank is still interrupted by bypass roads and by the settlements themselves and the wall, creating a colonial infrastructure that would render any Palestinian independent state in the future just inviable. These ongoing and present impact of settlers on Palestinians' daily lives were not mitigated by the UN efforts or by the international law efforts or even by terms of peace accords. Although settlements themselves are in violation of international law, more particularly Article 49 of the Fourth Geneva Convention, which prohibits occupying power from transferring its civilians to the occupied territories. Now, again, the United Nations have called upon Israel to end its settlement expansion and settlement activity in many resolutions. One of the most recent and actually most rare resolutions was 2334 made by the Security Council in 2016. What makes this resolution very rare, not that it called the settlements, Israeli settlements since 1967 a flagrant violation of international law, but that it was passed by a vote of 14-0. Even the United States did not use its veto to block the resolution, which delivered a very strong message to Israel that international community is one hand when it comes to Israeli settlements as a violation of international law. Now, for the wall, again in 2004, the ICJ concluded its ruling on the legality of the construction of the wall. It ruled that the construction of the wall is illegal in violation of international law, that Israel had an obligation to dismantle the wall and to repair any harm caused by its construction. Construction, nonetheless, continues until our very day. Now, when we move to the second demand of BDS movement, that is to recognize fundamental rights of Arab Palestinian citizens of Israel to full equality. Around 1/5 of Israeli citizens are actually Palestinians who remained inside armistice lines after 1948. These Palestinians face a systematic racial discrimination enshrined in more than 60 Israeli laws. They are regularly disposed of their lands and properties, and Israeli officials regularly and routinely incite racial discrimination and racial violence against them. Now, what Israel is practicing on Palestinian citizens of Israel and Palestinians who are not citizens of Israel actually amount to two different crimes under international law. We have the crime of apartheid and the crime of discrimination. Now, the crime of apartheid, which is more systematic, is prohibited in more than one international convention. It is prohibited under the International Convention on the Elimination of All Forms of Racial Discrimination. It is prohibited under International Convention on the Suppression and Punishment of the Crime of Apartheid, passed 1973, in which Article 1 of this convention considered crime of apartheid a crime against humanity. The same was addressed in Rome Statute for the establishment of International Criminal Court 2002, sorry. Under Article 7 of the Rome Statute, again, the crime of apartheid was considered to be a crime against humanity. Now, back to the International Convention on the Suppression and Punishment of the Crime of Apartheid, passed 1973. Article 2 of this convention actually lists number of practices that exactly meet what Israel is doing to Palestinians who are either citizens of Israel or not citizens of Israel. So we, for example, we have deprivation of liberty, deprivation of life, murder, inflicting a bodily harm, arbitrary arrest, unlawful prosecution, persecutions, we have discriminatory legislative measures. All these violations, if they are backed and motivated by racial segregation, would be considered a crime of apartheid. Now, moving to the crime of discrimination, likewise, a crime of discrimination is prohibited under many international conventions and international law. For example, it's prohibited under the Universal Declaration of Human Rights. It is prohibited under the ICCPR, the International Covenant on Civil and Political Rights. It is prohibited under the International Convention on the against all forms of racial discrimination, on the elimination of all forms of racial discrimination. This international convention actually makes it an obligation not only on states, but also on civil society organizations and movements to combat racial discrimination and to bring individuals who are involved in such crimes to justice. Moving to the third and last demand of BDS, that is the right of return, or to respect, protect, and promote rights of Palestinian refugees to return to their homes and properties, as stipulated in United Nations Resolution 194. Now, back in 1948, when a state of Israel was established, Israel committed war crimes of ethnic cleansing, resulting in a systematic forced displacement of around 7.25 million Palestinians around the world now. You know, the right of return, likewise, like other basic human rights, it is addressed in many international conventions, the Universal Declaration of Human Rights, the ICCPR, 4 Geneva Conventions, the International Convention on the Elimination of All Forms of Discrimination. It is also addressed in many United Nations resolutions. For example, we have the most famous one, 242, passed by the Security Council. But also we have the General Assembly Resolution 3236, passed 1974, in which the international community called the right to return an inalienable right of Palestinians. So here we can see how the 3 demands of BDS actually not only go in line with international law, but also it lies in the core of international law vision and goals. Now moving to the second framework from which BDS derives legitimacy. We have BDS itself as the movement as a manifestation of a combination of rights and freedoms deeply rooted in international law. Now, before I start that, I would like to say something about boycott. Now, boycott as a measure is not unusual in international law. You know, Article 41 of the United Nations Charter actually authorizes Security Council to take any diplomatic or economic measures to give effect to its decisions, including economic boycott. Now, this is for United Nations. When we speak about civil society and individuals, international law guaranteed freedom of expression for individuals and civil society. Now, everyone has the right to freely express his views in a non-violent manner, which includes participating in economic boycott. Of course, freedom of expression is not absolute. It has some restrictions, and it can be restricted actually under international law, but these restrictions must meet some conditions. We will talk about this in a bit. Now, the freedom of expression is not only guaranteed in international conventions such as the Universal Declaration of Human Rights, Article 19, and the key article here is the International Covenant on Civil and Political Rights, Article 19 also. But it was also addressed in many regional human rights conventions. So, for example, we have Article 10 of the European Convention on Human Rights, Article 9 in the African Charter of Human Rights, and Article 13 on the American Charter of Human Rights. All of these international and regional conventions actually address the freedom of expression. Now, according to United Nations Committee, freedom of expression is actually, it constitutes the foundation stone of a democratic society. It has both personal and social dimensions, and it covers many forms of expression, whether spoken, written, sign language, or even nonverbal expressions. And now, back to Article 19 of the ICCPR. Article 19 actually authorizes local authorities to restrict the freedom of expression. However, these restrictions must meet a number of conditions. For number one, it has to be prescribed by law. Number two, it has to be in a proportionate manner. Number three, it has to be necessary in a democratic society, not any society. It has to be proportionate in a democratic society, and it has to be taken to further one of two interests, either to protect rights and freedoms of others, or to protect national security, public health order, or morale. Now, when we examine the anti-BDS laws passed in United States and elsewhere, we will see that countries and states that passed anti-BDS laws did not meet the conditions of these restrictions. Now, on the other hand, we have freedom of assembly and freedom of association. Freedom of peaceful assembly addressed in Article 21 of the ICCPR, while freedom of association is addressed in Article 22 of the ICCPR. Both of them can be restricted only by law in a proportionate manner, in a way that is necessary in a democratic society, and also either to further and protect rights and freedoms of others, or to protect national security, public moral order, and health. Now, moving to the United States position. Now, the United States has a history of peaceful boycotts. It was either used to challenge human rights abuses or to change the environment, the political environment in the United States. The most famous of these boycotts in the United States is the 1966 NAACP boycott of white-owned businesses in Mississippi. A more recent boycott is the 2018 boycott of the National Rifle Association. Also, boycott has played a key role in international campaigns against apartheid, for example, in South Africa, in Darfur, elsewhere. Now, the unfortunate thing that is going on now in the United States is that the law is being used as a political tool. BDS is facing a fierce opposition here in the United States, both on federal and state levels. Now, since 2014, around 28 states passed anti-BDS laws penalizing not only institutions and organizations, but also individuals who are participating in BDS and boycotting or calling for the boycott of Israel. Now, laws in 14 other states are still pending. States that passed anti-BDS laws based their laws on anti-discrimination justifications, either a national origin discrimination against Israelis or religious discrimination against Jews. In 2009, actually, United States Senate passed a Combating BDS Act. The Combating BDS Act, through this act, the Senate seeks to authorize local and state governments to pass laws that would prohibit state investment in or even contracting with any entity that would either engage in boycotting Israel or call for boycotting Israel. Now, under this act and based on this act, many states passed laws that not only would prohibit state investing in these entities, but also would prohibit BDS as a pre-requirement or precondition for either government employment, public employment, or for government receiving governmental benefits, such as the case of Hurricane Harvey victims. Now, the American Civil Liberties Union has challenged the constitutionality of these anti-BDS laws as a violation of First Amendment and as a violation of freedom of expression protected under First Amendment. One of the most famous cases here is the Airbump case. If you can recall, Airbump announced that it would delist rentals in West Bank and East, in Israeli settlements in West Bank and East Jerusalem, because they go contrary to Article 49 of the Fourth Geneva Convention. After making this decision, around 4 lawsuits were filed against IRPAM. Unfortunately, this resulted in IRPAM reversing its policy in 2019. Now, anti-BDS laws passed by states in the United States is a content-based regulation of a protected speech that must meet strict scrutiny to pass the constitutionality test. Now, under strict scrutiny, any content-based regulation of a protected expression has to be justified by a state compelling interest and has to be narrowly tailored so as to further this interest. If the states had a strong and valid anti-discrimination justification to back their anti-BDS laws, this would probably constitute a compelling state interest that would trump First Amendment interests. Now, again, freedom of expression is not absolute. You have to take a step back whenever you're harming others' rights and freedoms, especially if they weigh heavier than your freedom of expression. However, freedom of expression and freedom of speech is not only about freely expressing your views without interruption. Actually, this is the negative side of the freedom. We have another positive side of the freedom here, and that constitutes a political right to try to affect, change, and shape a public opinion. And this right, according to United States court rulings, weigh heavier than individual interests and freedoms. Now, the leading case here in the United States is the NAACP versus Clybourne Hardware Company, 1982. Now, this state is about years long of Black people boycott against white-owned businesses in the county of Clybourne in Mississippi in 1966. This boycott was organized by the National Association for the Advancement of Rights of Colored People, and the main aim of the boycott was to compel political leaders to meet a list of 21 demands for racial equality and integration. Now, in this case, the court decided that non-violent, politically motivated boycotts are not only protected under the First Amendment and the First Amendment of the Constitution, but they also constitute a political right that weighs heavier than individual economic interests. Now, again, if BDS was, if the states that passed anti-BDS laws had a valid anti-discrimination justification, this to back the laws, this would end the story. However, BDS cannot be properly considered discriminatory. Why? To show discrimination in the United States, you have to show one of two under the law, either a discriminatory intent or a discriminatory impact. To show the discriminatory intent, you can use either a direct evidence or a circumstantial evidence. For the direct evidence, you have to show that BDS is facially discriminatory. Now, this is not the case. From day one, BDS made it clear that it is not targeting entities based on their national origin as Israelis. It is not targeting entities based on their religious identity as Jewish. Rather, it's targeting entities based on their complicity on Israeli human rights violations of Palestinians. In fact, BDS has called upon Israelis to join the movement. Many Israeli human rights groups joined BDS, and we have some, and many Jewish progressive groups joined BDS and played a key role in the history of the movement. Now, for the circumstantial evidence, actually, it is disfavoring a nation state based on or because of its governmental policies is distinct from national origin discrimination that would disfavor an individual because of the state that he came from, or the state he was born in, or the state from which his ancestors came. These are two different issues here. We can't call, for example, the United States boycott of Iran anti-Shia boycott, even if Iran self defined as based on religion, because Iran governmental and national policies rather than its religious identity are the target here. So now after examining, I'm sorry, back to the impact theory now. The impact theory, there is a disproportionate impact on Jewish communities in Israel because of the boycott called for by BDS. However, you can see two points here that proves that this disproportionate impact is not discriminatory. We can't consider BDS discriminatory based on the impact theory. Why? First of all, BDS has a business necessity to call for boycott. This boycott is called for as a measure to further a legitimate goal, so as to try to shift Israeli human rights practices. And second of all, and this is the most important here, is that these disproportionate impact on Jewish communities in Israel is the main responsibility of the Israeli discriminatory policies. Israel is trying to create a Jewish majority state. It's trying to create and even already created pure Jewish settlements. It's so natural this would expose Jewish communities to disproportionate impact of the boycott. This is exactly what BDS is trying to change here. So when we examine these legal points, we can see that states did not have a strong or even valid discrimination justification, anti-discrimination justification to pass their anti-BDS laws. These laws are in violation of the First Amendment, and using legislation as a means to suppress BDS is both anti-democratic and unconstitutional. Now, when we move to the second justification, here is the anti-Semitism justification. The anti-Semitism justification was not only used in the United States, it was used worldwide. Almost all of the countries that passed anti-BDS laws based these laws on anti-discrimination justification. For example, we have Germany. Literally compared boycott called for by BDS to the Nazi boycott of Jewish businesses. Now, the Nazi boycott of Jewish businesses was organized by a national government that discriminates against the minority group, whereas BDS is a civil society convinced struggling with discrimination practiced by a national government. So it's the other way around. Another thing here is that if Germany can recall, Jews themselves called for an anti-Nazi boycott. Jews in the United States, in Europe, even the Arab world called for boycotting Nazis, and the boycott lasted for roughly 8 years, from 1933 to 1941. And the boycott actually harmed the German economy to the extent that Hitler himself spoke against that. Now, unfortunately, what gives the legal force for these anti-BDS laws is that is the formal redefinition of anti-Semitism to include anti-Zionism. So, for example, here in the States, anti-Semitism was formally redefined to include the 3 Ds against Israel: demonization, delegitimization, and double standard deal with Israel. This is exactly what makes anti-Semitism part of anti-Zionism, part of anti-Semitism here in the States. Now, of course, we all know that Zionism does not reflect the views of all Jews around the world. For BDS, it's neither sufficient nor necessary for an entity to be Israeli or even Jewish to become a target. Actually, it has to be actively engaged in human rights violations of Palestinians, or at least aiding and helping in maintaining Israeli apartheid regime. Now, linking anti-Semitism with Israel would actually harm Jewish communities around the world. Israeli actions are indefensible. This would be wrongly translated as if Israeli illegal actions are representing Jews around the world, and would eventually be reflected in further cases of anti-Semitism. Now, the Israeli position, I don't have to speak much about the Israeli position. It's very obvious that Israel opposes BDS from first day. Now, in 2011, Israeli Knesset passed a law that would allow individuals to seek, to bring lawsuits and seek damages against anyone who publicly calls for the boycott of Israel. And here the term Israel includes Israeli settlements in West Bank and East Jerusalem. Also in March 2007, there was an amendment to Israel entry laws to authorize authorities to deny entry into Israel to any activist who would publicly call for the boycott of Israel. Now, both U.S. position and Israel position goes contrary to the United Nations guiding principles on business and human rights. The United Nations, in these guiding principles, it clearly said that businesses and companies have an obligation to identify and mitigate serious human rights violations across their operations. Now, if a business is contributing to human rights abuses and violations, it has an obligation to seize and prevent all contribution and all the human rights abuses, and to mitigate the harm caused by them to the greatest extent possible. Now, if it can't, then it has an obligation to terminate and refrain from entering this operation from the first day. Now, businesses cannot do, companies cannot do business in Israeli settlements in West Bank and East Jerusalem without possibly violating Palestinians' human rights. So just to conclude here, in 2005, the ICC International Court, Criminal Court, initiated a preliminary investigation into the alleged Israeli war crimes, including the violation of expanding settlements. And now the investigation is still pending. But regardless of the ICC decision whether to bring formal charges against Israeli officials who are engaged in violations, the ICC can only prosecute governmental officials, individual governmental officials. So whereas the colonization of West Bank and East Jerusalem involves a broad matrix of people and policies, and eventually these charges will be challenged by, will face impunity challenges. This makes BDS a winning card for Palestinians. Palestinians waited a long time before going the route of boycott. Only after Israel ignored international law, ignored terms of peace accords, ignored dozens of United Nations resolutions, ignored the ICJ decision, ignored the repeated condemnation by international human rights groups, only then Palestinians start to boycott, maybe as a final step and a final solution to ending the apartheid regime maintained by Israel over Palestinians. Now, prohibiting BDS comes as a part of a propaganda to whitewash racism and cover up for Israel's crimes against humanity, including war crimes and and crime of apartheid. This would send the wrong message not only to Palestinians and Palestinian civil society, but also to human rights defenders across the world that peaceful means just don't work. Try to find something else. From my end, that was it. Thank you so much for listening. Now back to you, Rania, if anyone has any question.
Thank you so much, Hiba. That was truly amazing and very informative. Someone asked for a recording. This is being streamed live on Facebook, so you can definitely watch that right afterwards. It is saved on our Facebook page. We also have all of our lectures all posted on YouTube within the week. So please make sure that you check them out. And yes, I agree. Bravo. Absolutely amazing, Hiba. That was very informative, and you were able to include so much information in such a short time. That was truly informative and a lot that we learned from that. So Wali asks, was the boycott against apartheid in South Africa considered illegal by any group or state? And he wants to specifically know a little bit more about the US and Israel's position on the apartheid.
Okay. Now, a boycott again is not unusual in international community. It can be used. It's a form of freedom of expression, even if the international law does not say it in word that boycott is a right. It is considered a kind of a form of freedom of expression. This actually was ruled upon 10 days ago. You know, the European Court of Human Rights ruled on a BDS activist case. BDS activists were convicted in France for entering a supermarket with a T-shirt written, you know, has a boycott Israel slogan, and were informing, you know, and asking customers to boycott Israeli products, to boycott apartheid. Now, the France actually, French courts convicted these activists based on anti-discrimination laws, whereas the European Court of Human Rights said that these convictions are actually in violation of freedom of expression. One of the forms of freedom of expression is participating in boycott. The right to boycott is a part of freedom of expression, whether in South Africa or elsewhere. Now, what is the Israeli and the United States position on apartheid? Unfortunately, Israel is not a contracting party or a contracting state in the International Convention on the Suppression and Punishment of the Crime of Apartheid, BAS 1973. But however, even if it's not like a contracting party, many of the terms of these conventions, international conventions, whether on apartheid or other crimes, you know, especially crimes in armed conflicts, are considered a customary international law. Now, customary international law makes these terms and these conventions binding even on non-contracting and non-signatory parties. I'm not saying that the whole convention can be applied to Israel or the United States, despite the fact that they did not ratify or did not sign the convention. But the main and basic terms of these conventions, especially that the crime of apartheid is also addressed in Universal Declaration of Human Rights. Now, the Universal Declaration of Human Rights is a customary international law. So these crimes and these international terms, even if not ratified by Israel and the United States, they are still binding as customary international law.
Thank you very much, Hiba. Wally asks another question. He says, we boycott some products here. It's our First Amendment right. Why do we have to issue laws on behalf of a foreign country?
Again, I'm sorry, I didn't understand the question.
So I think the wording's a little off, but I think he's asking, like, it's our normal First Amendment right to boycott. Why are there laws that are issued when it comes to a foreign country and boycotting it?
Okay, so again, I would remind you, Wael, is his name Wael or Wali?
Wali, I believe.
Okay, so I just want to remind you that the United States here is basing anti-BDS laws on anti-discrimination. Now, this can be off you when we speak about anti-discrimination, because this is a very restricted group. We're talking about Israelis, and this is one of the criticism this is a main criticism of these anti-BDS laws, is that it's targeting discrimination against Israelis. Now, discrimination in the United States is prohibited, whether racial origin, national origin discrimination or religious discrimination. You cannot discriminate against anyone because of the country that he was born in, or because of the country from where his ancestors came, or because of his religious identity, whether Jewish or Muslim or Christian. So what the BDS is trying to do here, again, it's obviously using the law as a political tool. But the justification here is anti-discrimination, to protect its citizens or residents of United States, especially Israelis and Jews. And we said that this anti-discrimination justification is not valid. So anti-BDS laws are still a violation of First Amendment, and this is what the American Civil Liberties Union is trying to prove.
So I guess I have a question, Hiba. So when you're dealing with the BDS laws, and right now there's obviously a lot of pressure to have people stand against it, what are some, I guess if you want to like summarize some points that people could use to explain why BDS actually should not be illegal and why it's actually very important? Because you started talking about this, if you can get a little bit more into that.
Okay, so BDS cannot be prohibited in the United States, especially. First of all, because United States, like other member states of international community, must comply with international law, especially customary international law. So BDS is protected under international law and under regional law. The regional conventions and international conventions guarantee freedom of expression, and economic boycott is one measure and one form of freedom of expression, and the U.S. has to comply with that, because even if it's not a contracting party to some of the conventions, it's still party to other conventions that guarantee freedom of expression, and other conventions that the U.S. is not a party to can be considered customary international law. Also, United States have the First Amendment to the Constitution. The First Amendment it considers freedom of expression and speech to be, we have protected forms of speech and expression. Now, whenever the law targets the content of the speech or the content of the expression, it has to meet strict scrutiny. Strict scrutiny is the highest level and the highest test in the Supreme Court, in the United States Supreme Court, to test the constitutionality. If it did not pass strict scrutiny, if the law did not, if the regulation made by the state to restrict BDS, the anti-BDS laws, did not meet this strict scrutiny, then it's a violation of First Amendment. Now, to meet strict scrutiny, you have to show the state that passed the anti-BDS laws has to show that it has a compelling interest that justifies the restriction, and this regulation that would restrict the expression is actually narrowly tailored so as to further this interest. Now, again, anti-discrimination in general is a compelling interest of a state. It can be used to trump First Amendment interests. However, in this case, there is no valid anti-discrimination basis, because, as we said, BDS cannot be considered discriminatory. It is not targeting Israelis as Israelis just because they are holding the Israeli citizenship or just because they live in Israel. Let alone targeting Jews as because of their religious identity. It's only targeting entities that is involved in human rights violations and abuses. It can target a Russian company, for example, that helps Israel to maintain its apartheid regime. It can even target a Muslim organization that helps Israel, or there are some Arab states now that would help Israel financially. It doesn't matter, Israeli, Jewish, Arab, Muslim, doesn't matter. This is not the criteria for BDS. That's why BDS is not discriminatory. It's an inclusive, anti-racist movement that opposes all forms of discrimination, including anti-Semitism and Islamophobia.
Thank you very much, Hiba. So we're going to take the last question of the evening from Lee, where she asked, how do individuals participate in the BDS movement? Will it be successful only if multiple governments begin to support this movement on a global scale?
Okay, now the main idea of BDS is to involve individuals. BDS was created only when governments failed to hold Israel to accountability. It was created as an alternative to use individuals and civilians to show their support to the Palestinian cause. Now, of course, if governments participate in BDS, they would have more effective measures. They would show especially economic impact, more economic impact of the movement. I think the movement succeeded in raising awareness, in showing the world the violations of the Israeli violations of human rights, but it's still reluctant when it comes to economic impact, because the economic impact, as I said before, needs more governmental involvement here. But still individuals can do a lot. You know, the urban case, one of the good examples here, although the urban ended up reversing its policy in 2019, still the individuals and their campaigns in universities, in their communities, bring attention to the Palestinian cause, and they raise awareness about the Palestinian cause. As I mentioned before, 3 or 4 Palestinian activists were actually convicted in France for wearing the t-shirts with the slogan, and their case went up to the European court. This made like a big effect in media and spread the word.
Thank you very much, Hiba. We do have one more question. Do you have time for one more question?
Okay, I can take one. No problem.
Okay, so Michael asks, any advice on how to start a divestment campaign, whether it be on a university campus or to pressure a company to divest from doing business with an Israeli company?
Okay, so there is what is actually representing BDS, and you can contact them, is the Palestinian BDS National Committee. Palestinian BDS National Committee was established in 2005, and it actually coordinates BDS and has a guiding principles. You can contact them, ask them how to get involved. They have a website. You can talk to them, and I'm sure they're gonna help you with this.
Thank you very much, Hiba. Thank you for all of you for attending and asking wonderful questions. We want to remind you all to please make sure to take the census at your earliest convenience, and we also want to challenge you all to get 5 other people to take the census as well. These webinars are brought to you by PAC, so please don't forget to see a full list of all our upcoming events and programs, and to donate to keep these programs going. Please visit www.paccusa.org. Thank you again, Hiba, for a very informative lecture.
Thank you.
We hope to see you all, and please remember our next Palestine Monday will be July 27th, and we're going to be discussing normalization. Thank you again, Hiba. Have a wonderful night.
Thank you. You too, guys. Thank you so much. Thank you.